Good evening, everyone, and welcome to the Legal Contracts and Board Policy Committee meeting on this Monday, March the 17th, St. Patty's Day. Welcome, everybody. For our first order of business, we will have previous meeting minutes. Is there any questions on the previous meeting minutes? No question on the meeting minutes. Next, we will have number 2, public participation. Is there anyone who wants to come and talk to us about anything this evening? No one's here, so therefore we'll go to number 3, discussion topics. We will have our first 3.01 reading of a nepotism policy. Ms. Carter.
All right, so on this agenda for today, we have the nepotism policy, and this will be a first read. So I'm just going to give you an opportunity to look this over. I know that we've looked it over a couple of times before it ended up in being a first read. And so I didn't know if we had anything we needed to do, if we're okay with moving this on to a second read for the on board docs for the first meeting in April.
Anybody have any comments, questions, anything they want to discuss in reference to the nepotism policy?
Dr. Molinar?
Oh, Dr. Mola, I'm sorry. Go ahead.
Hi, thank you. I have a general question. I don't know what is normal, but so for purposes of this policy, a family member includes the following: spouses, parents, siblings, children, grandparents, grandchildren. So in this policy, that would not include someone that you are living in the same household with, as long as the person is not a spouse, child, or grandparent.
Now, Mr. Wallace asked me, do I need to come? But no, that wouldn't include, that is something that we did not even actually, that never came up in any of our discussion as relates to if I'm living with that person. So if we're roommates, but no, that didn't come up in discussion actually. We just looked at family member. So spouse. So what do you guys think, the committee?
Well, anyone have anything else they want to discuss about it? If we think that we may need to have this discussed and talked about, taken back, if we need to, we can do that. It's up to everyone. We can, or we can move forward. Was it please everyone?
I know that in reviewing, just when we were looking at different policies, and even the one that we looked at from Cleveland, I've never ran across anything that mentioned dwelling in the same household. They mostly referred to the family member list.
So it's more or less blood relatives, correct?
Yes.
Okay. Pastor Harris?
Thank you, Mr. Chair. I know we discussed this policy and the language, and I don't want to speak for Member Molinar, but I want to say, do we have a conflict of interest policy?
We do have a conflict of interest.
We're moving more to conflict of interest in that situation when we're talking about someone in the house. And so we may, Mr. Chair, want to just put an eye on these two policies together to see if we are capturing what we need in both policies. This may be an opportunity to review both policies to make sure we are not talking in conflicts.
Absolutely. And we do have a conflict of interest policy. And so we can keep this on as a first read and bring the conflict of interest policy and look at any overlaps, because that is something that we looked at before we even started working on the nepotism policy. When that was brought up, we wondered, was the conflict of interest policy enough? But this went even deeper than the conflict of interest policy. But we'll bring that back to the next meeting, and we can keep this as a first read, if you like.
Is that pleasing to everyone? Pastor Harris? I'm sorry.
Mr. Chair, yes.
Yes.
So we do have a conflict of interest policy. There is a need for us to have a nepotism policy, which the two will work hand in hand together. But the nepotism policy goes into much broader, much more specificity and detail than the broader policy of conflict of interest. So, but there is a need for the district to have a nepotism policy that would address the more linear matters and concerns that we deal with.
I'm sorry, go ahead.
And I'm not discounting the need for the nepotism policy. I just know that if it's both of them are purposed, and so because they are closely related, we can take an eye at both of them at the same time to make sure we're capturing the purpose of the policies.
Is there a time frame that we really need to have this one done? Oh,
No, this is not a Neola update or anything that's mandated through legislation or anything, so we do have time.
okay, so why don't we just take this and put it for another reading, the next meeting? Give you guys that opportunity to look at the conflict of interest and this here nepotism, and then come back with some information for us so we can move on from there.
Absolutely.
Would that be okay with everyone? Okay. All right, thank you. Okay, Ms. Carter, continue.
Next, we have up for discussion is our vendor relations policy, and I'm going to have I'm going to have Ms. Folk come up and share an overview of this policy.
Rid of that sidebar. Good evening, Chairman Alexander, Vice Chair Mr. Harrison, members of the board, Superintendent Robinson, and Ms. Carter. This is a policy that has been on the books for some time, since 2012. It has gone through some changes. The first one you will see in the first paragraph is the fact that it is regarding the author, which is properly approved of educational material. What we are adding on this one is providing the authored educational materials were not created during the employment of the district or created using board funds, because the original paragraph allowed the royalties to go to the author. But we felt, and we have worked with legal counsel, that educational materials done in the employment of the board or using funds associated to the district, whether it's a grant or other funds that the district actually use, means the intellectual property rights belong to the district. So that was a change in that location. And I will advise this did happen several years ago, and a letter of cease and desist was provided to the people that were involved in this. Let's see. Can I get this to move down? Some of these are just educational changes as far as grammar. The next part is the requirement for certain technology provider contracts. This is a new addition to this particular process. It gets our policy currently in line. This was provided by Neola. This allows us now to be in compliance with the federal statutes for technology providers and House Bill 29 here in the state of Ohio. So therefore, as an example, any technology data sharing, and I will give you testing data sharing, curriculum data sharing, that we share the data with the vendor, there are policies, they must now be in compliance. And this is why you have this extensive update to this section. And this was vetted with our technology team. They went through House Bill 29 specifically to make sure that this was put into place along with the rest of the contracts that we currently have. So that is my update as to why these changes are coming for the first read.
Thank you, Ms. Folk. Any questions?
I have a question.
Pastor Harris?
When we're looking at the requirements for certain technology providers and so everything that is in green has been added?
Yes, that is correct.
Okay, so, and that language came from?
Some of it is federal statutes as to what can be done, but here in Ohio, it's House Bill 29.
And I guess that would be my question. Is this language, the legal language that comes directly from the statute that's in part of here?
This was provided from Neola as they went through the legal statute as written, and this is the language they provided in their update to us.
Okay, so have our attorneys taken a look at this?
Yes, it was vetted through our attorneys and during a previous review. That is correct.
Thank you, thank you.
Much of it is related to if we are turning over student data to the vendor. A lot of it has to do with the protection of those records, especially when a destruction is needed to take place due to the end of a contract. We have not included that vendor in the next round, or when there's been a breach. There's very specific things that we need to do with this. Thank you.
Okay. Pastor Harris?
I have a question based on access to student information. And again, we go back to the Raptor system. So it's not just providing a vendor with information, but when a vendor has access to information, whether it be students or employment information, are we vetting these things together?
In this particular case, these files are requested by the vendor because they have to be in a specific format for them to allow them to have access. It is vetted. The file is sent directly to the vendor only. They don't have access to the files within house. It is the file that we send. It is good for the time frame of what they needed for, whether it's testing or education materials, and then it is updated if necessary. It's only a transfer as a file. So they do not have access to what I would say is live data, if that's what you're asking.
No.
Nope, I still didn't get
No,
it.
no.
Okay.
And I guess I'm not specifically speaking of one particular vendor.
Mm-hmm.
Okay, but I'm saying when a vendor has access to data, when they have access to data, that's what I'm speaking of. When for whatever person, if it's a one-time, if it's a contractual access, and I'm just using a Raptor as an example. That's data that you can't get back. When you scan that card, that's data that it's used for a purpose, but that's still a collection of data.
Yes, that is correct. But it is contained within the vetted system that we purchased, and it must meet the requirements of use under the contract.
So let me see if I can. So are you saying, Pastor Harrison, is that the information that we give to a vendor, if we give it to them, is it secured and is it safe? And if we need to, can we get it back?
Yes.
Secured and safely, is that?
The contract states at the end of it, when it ends, that those items are returned directly to the district. If it is a breach, they are to cover the breach with us and make sure that it is reinstituted and sent back. There is another form that they do sign stating that they will follow those protocols. But this was an update that came last October from House Bill 29, following the budget bill.
Okay. Does that answer your question? Okay. Anyone else a question? Okay. Thank you, Mrs. Folk.
So this is still in this is discussion. Are we ready to move this to a first read for our next committee meeting?
Okay. I think we can probably go ahead and move it, and if we need to have more discussion, we can bring it back to the next meeting and have more discussion, even if the question that Pastor Harrison has, if we don't have it right now, gives us time also to get that answer, and then we can come back and move forward. So I think it's okay to go to first read. Is that okay with everyone? Okay. Thank you.
Thank you. Next up for discussion is our independent contract operator policy, independent contract operator and service provider policy. I'm going to have Ms. Folks speak on this particular policy.
Okay. Thank you. Good evening again. This actually came out of a discussion related to vendor relations. And we, as you know, we have an internal contract review policy or group as we bring items to the board. And we certainly have had a number of independent contract operators that provide, or service providers that individually provide items to us. This is an addition to the vendor relations because these are actually vendors that service us in a number of ways, and we try to delineate exactly the definition of an independent contracted operator is an individual or business entity engaged by APS under a contractual agreement to provide specialized services without being an employee. And ICOs operate independently, control their work methods, and are responsible for their own taxes, their insurance, and business expenses. A service provider is also a provider of service, and it is a business or organization contracted by APS to deliver services essential to the district. And these service providers include, but are not limited to consultants and vendors and professional services. And I'll use as an example two. Under independent contracted operators, as an example, you are aware, we have van services, we have individuals responding to an RFP for health services. So as an example, our school nursing clinics are operated by Akron Children's. A number of school districts in the areas actually have employees. These are services that we must provide, but we do it as an independent contracted or answer to an RFP. Now, we went through this independently or individually to say what the eligibility requirements were. To be an ICO or an SP, the individual contracted unit must provide this following. It is a signed contract written or provided by us, or possesses a valid signed purchase order, because those are the ways you engage these particular independent providers through payment and engagement for their services that are delineated in a scope of work. They must not be subject to direct supervision by APS. So I'll give you an example. When we are working with our Akron Children's contract, we engage them, we tell them what we want, but their direct supervisors are the school health division of Akron Children's Hospital. The same thing would be, as an example, for Peterman. They provide school transport, and in that case, they are a service provider for something that's mandated. We give them the information on the students in the schools, but they do the actual assignment and direction of those buses and those drivers. And the same for van services, occupational therapists, PTs. Those are the services that we're looking for here. They must possess the necessary licensure, certification, and insurance required by the law and the nature of the service provided. And they must comply with all of our APS policies, including background check requirements when working with students. And those are specifically written into the scope of work that we are looking for. Under the contracting processes, we have also delineated that. These engagements must be approved through the APS procurement office and reviewed for compliance with state and federal labor laws. And we have also engaged legal to help us also look at some of those procurement standards in federal labor laws. The contracts or purchase orders must clearly define the engagement, including the duration, which you see often as we write business affairs recommendation. It gives you an effective date and an end date, along with the payment structure. Most of ours are invoiced on 30 days with 30-day payments. If they're large contracts, it may be an individual service contract and the payment is at the end of the service term. Think of the people that you recently put to board to be the adjudicators or judges for the musical events that our students currently participated in. And then there are confidentiality agreements and termination clauses. And then we reserve the right to audit and ensure compliance with contractual obligations. We not only can ask for those records for our own auditing purposes internally with the Treasurer's Office, we actually will provide those as requested by the state auditors when they come in to do a regular annual audit. Then we went on to restrictions and prohibitions. They are not entitled to APS employee benefits, including health insurance, retirement plans, workman's compensation, or paid leave. And then the last part of this was APS employees cannot be classified as an ICO or a service provider to perform their regular job duties under a separate contract. This one has come into play, and I will give an example. We might have somebody who is doing service as a tutor, as an example, but they only are engaged, say, for so many hours a week, but they'd like to be an independent contracted van driver. Per the IRS regulations, you cannot get a W-2 for being a staff member and what is called a 1099 as being a vendor. So in those adjudicators that we recently did for the Fine Arts Department, those people actually checked on their contract service that they are not an employee of APS. And then the compliance and oversight for these independent contracted service providers would be through our procurement office and our legal department, and any violations of these policies may result in termination of the contract and any potential legal action. So as I said, this was brought up as we were working on the vendor relations, because we've gotten into a number of independent contracts more recently than we have over the years, and we wanted to make some definitions very clear.
Thank you, Ms. Folk. Is there any questions? Dr. Molnar? You have a question too?
Thank you. So I heard you say that this policy came from working on the vendor relations policy. I am happy to see an independent contract operator policy, because I brought one to this committee in October. And so I was wondering if, as your team drafted this policy, I know I provided the committee, but there has been turnover, with an 11-page document of what included my proposals and where a lot of that information came from. Ohio Department of Job and Family Services, and also other schools and even some universities. So was any of that used?
Yes.
Yes, it was.
In this? Mm-hmm. Okay, because there's a lot, actually almost nothing that I can see. But for instance, can you please help me understand then, in the document that I provided the committee, there were several letters of what would, I guess, be in some of these eligibility requirements. So I don't know if you'd want to go through. It was to define independent contractors by various criteria. And so there were a lot. There's A to P of those criteria. So I don't know if you have that, since this document was never able to be discussed by the committee that I presented in October, if you have any perspective on why some of these, maybe we don't need them in the policy.
This was actually a first blush on putting this together as we did, and your items were referred to. We didn't want to get so detailed that we couldn't have some flexibility going forward. That doesn't mean that we wouldn't consider some of that in the future. It was just a first blush to get it together, because the vendor relations obviously needed to go to board to be updated, and we thought it was a subsequent support of that review of that policy. As this is just a first blush, and we wanted to make it distinct and easily understood for those that truly go out and look at our website, and for us to have an idea of what we could do to begin with. And this issue of what is an employee and what is an actual independent contract is a very fine line, and legal works very diligently with us on this, because there are certain things we are required to do as providing services to our students and our staff, and we just need to make sure that we can have a first blush on this to have it move forward. This wasn't a first read, it was a first blush to make sure that we got it together to support the movement of the vendor relations going forward.
And when we started the process, we started with what the information that you provided. So we did start with looking at that first. And then some of the information in there didn't pertain to a school district. It was like college level. It was, and so we tried to pull out the things that would make sense as it relates to the district work. So I don't know if Haley, if you had anything else to add.
was also, I mean, we did look at that language, and there was some of it that conflicted with the contracts that we have in place at present, and we didn't want to restrict ourselves from being able to enter into contracts that didn't follow the policy, because some of the draft policy, the initial draft policy, had some conflicting language that we wouldn't be able to put on our books for a policy. So, like Ms. Volk explained, this is just a first iteration of this, and I think that we're happy to include more details as we see fit, or as the committee sees fit.
Yeah.
Your follow-up? Go ahead.
Thank you. That is very, very helpful, and I'm very curious about what would have been in the policy recommendations that I created that conflict with the contracts that we're offering people. I'm very curious about that. But since this is kind of a first draft, first read, so I'm guessing that means it's coming back to this committee. So if I found some areas that I think it might, so who should I send that to? Angela? Thank you.
Pastor here. Pastor Harrison.
Thank you, Mr. Chair. I have a couple things, and I would like to speak with legal as well. Being that this is the legal policy and we are creating policy, I would like the board to work with legal, to have more interaction with legal when we are creating these policies. And that was kind of interesting that some contracts that we have now would not, it would be difficult. It wouldn't be clear. Yeah. So one of the things that I see in policy is taking away arbitrary decision making. And I think that's, for me, where we get in trouble with creating a policy, is when we want to leave ourselves enough room to be arbitrary. So I have a couple of questions on this particular policy, but I would like to see the document that Member Molnar presented to the committee. How do we handle the SROs? Because I know a lot of them work the schools, but they also work our athletic events, which we need them to. We need that continuity.
There actually is a board-approved contract for the SROs to be in the schools. You just approved one at Monday's meeting to get them through June, and that is specific, and then they're hired as staff members through the independent, or through HC, to help you with the events that you were talking about as part of the security.
Okay, I appreciate that. But on its face, again, we're conflicting with what we're saying here. So I'm asking, how do we handle SROs? And we need them to work games. We need them to work as security during our games. So how do we handle that? Because they are being paid by the city, but then they're also, I'm assuming we're paying them as well?
Did you want to speak or you want me to?
Well, we're paying them for the extra work that they're doing. That's not included in the original contract that the board has with the city around the SRO portion of the contract. What they do outside of that is something very different, and that's kind of an individual thing on their own within those guidelines, and that's how we're able to pay them, because they're not in their contractual time. They're working now as a regular officer, but independent of their contract.
Yeah, I understand that, but that conflicts with, okay, so we're paying the city for a service. So we are in a contract with the city.
Right.
Okay. And now, let's say Officer Smith is working in the schools, but Officer Smith also works football games.
Right.
Okay, as not part of his duty assignment. But at the end of the day, for the IRS purposes, he is still John Smith. And so I think when we're looking at a policy like this, we need to understand that we have these situations, and that's where we would have to give ourselves some leeway, because we need the continuity of the officer who works in the school also working in the extracurricular. We need that continuity of that same officer, but we're running into this thing now because you got one person and he's getting paid to do the same work, basically.
Yes, sir. But his daytime work is contractual, and that's through the contract, that the agreement that we have.
Right.
But what he does at night is on his or her, because there are some female officers too. There, it's based upon their own personal choice to work and help us support our athletic events and any other events that we might have that we need security.
Right, right. Yeah, and I understand that. So he's working as a police officer in the daytime.
Right.
In the building, but he's working as a police officer in the nighttime as well. And I guess that's what I'm saying. We're paying for police services. And we just need to look at that with the contract.
Yes.
We're not, the other thing with the independent contractor and service providers, I would like to see in the policy that it is pending board approval. That any contract is pending board approval. I would like to see that included in the language of the contract. I mean, in the language of the policy.
Any other questions? I do have a comment. And I appreciate Dr. Molnar giving that document so they can look through it. But one thing that my experience of being in policy is that I never want to see us too much in a policy where it handcuffs us, where we can't do some things because you need that leeway. And so one thing the Akron Public Schools is good at having is those administrative guidelines, and some of this stuff might be able to use possibly in administrative guidelines versus being in a policy, because that way you don't tie your hands. Because we put too much in a policy, that means you have to follow all this. If you don't follow it, then you're violating your policy that you made. So we need to probably just keep them as short as we can, but also include administrative guidelines with some of them. Okay, that was my comment. Anybody else? Okay, and so this is also not even a first reading, just for discussion, and we will bring more information back as needed. Make note that the questions that have been brought up, so we can try to get that information back for the committee at the next meeting. Okay, I'm sorry. Go ahead, Ms. Carter.
All right. So for discussion for next meeting, as of right now, we still have our nepotism policy and the independent contract operator and service provider policy. Also, with the nepotism policy, we're going to be bringing back the conflict of interest, just to sum up where we are right now. Next, we're going to have Dr. Lash come up, and she's going to give us an overview of the Parents' Bill of Rights, which is in discussion right now.
Good evening, Board Committee Chair, board members. So this policy satisfies the requirement of the Parents' Bill of Rights to promote parent involvement and parental notification on student health and well-being, and instructional material that has sexuality content. So if you take a look at this policy, it first begins with definitions to kind of define age-appropriate and developmentally appropriate, as well as students' mental, emotional, or physical health or well-being, and sexuality content. So it starts with those definitions, and then it goes into the section here on sexuality content and parental notification. And this is model policy, so it does include all of the required statements. And so particularly in this section, you'll see the first line The board will ensure that any sexuality content is age appropriate and developmentally appropriate. So again, those definitions before. And then you also, in the second paragraph there, see the statement that the board will provide parents the opportunity to review any instructional material that includes sexuality content. And again, those were required statements. In the next section on student services, mental, emotional, physical health or well-being, safe and supportive learning environment, and parental notification, in that first line there, again, you'll see required language that we are to notify a student's parent of substantial changes in the student services, including counseling or anything related to monitoring the student's mental, emotional, or physical health or well-being, that we are to do that notification. And then in the second section, or it's one sentence, so I don't know if we call it a paragraph, but where it says school district personnel will not directly or indirectly encourage a student to withhold from a parent information concerning their mental, emotional, physical health, or well-being, that was required language as well. In the next section, procedure for authorization from parents for health care services, this section is, again, around notification. You'll see that theme kind of running through this Parents' Bill of Rights to notify parents of things. And so in that second paragraph where it starts to facilitate parental involvement, you'll see language there that speaks to the district notifying parents of each health care service that's either offered at that particular school or anything that we would facilitate that would be happening at that school, and then to also give the parents the option to opt out, to either consent or decline those services. And then 1, 2, 3, 4, in the fourth paragraph there, you see the X because we are accepting that optional language there that at the beginning of the year, as we do annual notices to our families around certain required topics anyway, that we would add this to that annual notification. We will notify parents of known health care services. Okay. And then in the next section, process for resolving parental concerns, language included here that there will be a process for families to file any concern that they would have about any topic that's related to this policy, that there would be a process for that, and then, of course, resolving it within a time period. And then in the next section, parent right to inspect instructional materials. Again, this is with regard to sexuality content. So you see that first line, parents have the right to inspect instructional materials used as part of the sexuality content component. And so essentially, again, this satisfies the requirement to have Parents' Bill of Rights that we are to adopt by July 1. So we're early.
Thank you, Dr. Lash. Any questions for Dr. Lash? Dr. Molnar?
Thank you, Chair Alexander. In this Parental Bill of Rights, I know a lot of this gives parents the ability to proactively be involved, and they have the right to be involved and to receive the information that they are desiring. But in the very top of this, I want to kind of react to what I think some of the intent of this also is for families to be informed of things that they might not be aware of and to be presented with that. And so looking at this first paragraph here, very simple. In the second sentence it says, in addition, parents have certain rights in the school system to know about the student's educational experience. But as we write learning objectives and all the time, all these things, how do you know if someone knows something? I think to know is a good example of when a policy needs to be more specific and to leave less to administrative guidelines. And I wonder if we can put something there. Parents have writes the right to know, but maybe the district has a right to, or the district should inform, or parents have the right to, in the section down here where you talk about age appropriate and developmentally appropriate, this list, parents have the right to be informed, or the expectation to be informed. Parents have the right to receive documentation. I think there's an opportunity here to be more specific and proactive about informing parents of things that are happening here.
Excuse me, Doc, where you at? I'm lost. Where you at, Dr. Molnar?
Sorry.
I'm lost on where you're at.
So I am trying to open the floor really for discussion of opportunities here, but I think we should change at minimum at the top to no. And the reason why I think we should change to no is because how would we know if a parent knows? I think we should be more specific, and A through E right here is the reason why I think we should be more specific. And I see C here, for instance, refers to Ohio Revised Code, and that one says, access to written reports, so maybe provided documentation. So my recommendation in summary is in the very top to change parents have certain rights in the school system to know. I think we should change parents have certain rights in the school system to receive documentation about their students' educational experience. Or something else, because how else are we measuring what they know? How do we know what they know?
Thank you, Dr. Molnar. So just to comment on that, I understand that sentence is kind of strange and vague, especially considering the detail of the rest of the policy. That's actually, I believe that Neola put that sentence in there because House Bill 8 specifically says that the policy shall specify that parents have an inherent right to know about their students' educational experience. So that's where that language is coming from. Of course, that can be tweaked to be better, or more fitting for APS's policy, but I believe that is where that's coming from, and then with the specific rights listed further. But I think that there's probably room for more specific language further on in the policy, but I do think that most of those concerns are addressed throughout.
Follow up? Go ahead, follow up. Yes, so I think from the bold at the bottom here, sexuality content and parent notification, I think that is when parents are notified, but I did not see, so that is for A through E, I did not see where parents would be notified of those.
So it's in each section. So like that section that you just referenced is specific to sexuality content and parental notification. So it speaks specifically to that. And then when it goes into the next section about student services, mental, emotional, physical health, well-being, safe and supportive, that kind of thing, it talks about notifying a student's parent of substantial change in the student services, including counseling services or anything that's related to their mental, emotional, physical health and well-being. So in each section, you'll see language that speaks to notifying parents. I think Attorney Kepcher, I don't want to, but maybe is what you're referring to.
Yes, that's right. Thank you.
We're going to move on.
Thanks. So for C in particular, can you please just help me find where parents would be notified proactively by the district and not reactively from a parent question?
So if you're speaking specifically, however, to harassment, intimidation, or bullying, there is a policy specific to that. But that is in the student services, mental, emotional, physical health, well-being, safe and it's a long mouthful there. It talks about it generally, the student's mental or emotional, physical health and well-being. So that's what I'm saying. If you're looking specifically for those particular key words, it's not calling them out here. And I don't know if Attorney Kepchari, there's a separate policy that deals with that, but if you want to speak to.
That will go to my point.
Yeah, I don't have the separate policy in front of me. I believe that there would be notification provisions in our bullying and harassment policy that would probably be found in there. This policy, I think, is meant to fill gaps that House Bill 8 had identified and therefore enacted these certain provisions. So this is very specific to House Bill 8 and the Parents' Bill of Rights. So things that are not within House Bill 8 are not in this policy. But that being said, if the bullying policy needs to be revisited to see if there's notification there, then that's something that we can look into. Like I said, I don't have the bullying policy pulled up right now, but I would expect that it would have some kind of notice requirements in it, but that's something that we can look into.
Yeah, 5517.
Pastor Harris, while we're doing that, go ahead.
I have a couple questions. So with this policy, with this Parent Bill of Rights, is this directing us to do anything that we're not currently doing?
The things that I can think of, and Mrs. Folk might want to speak from the health services standpoint, as we talked in the committee about some of the health services that are, I don't know that we include that in our annual notices as things happen in the building, if there's like a dental drive or eyeglass drive, I don't know, I'm making up stuff. But those kinds of things that happen in the building, that notification would come, but in an annual notice, that will be new. I don't know if you want to add. Mrs. Folk.
One of the things we wanted to make sure was to cover exactly what happened should something happen to a student on campus during the day. There are health services. Obviously, we have health clinics in all schools. There are times that parents may, as they enroll or reevaluate their decisions each year, they need to decide if they're going to allow us to provide medical services because they've given us a yes or they've given us a no. And there are times if they opt out with, no, I don't want you to perform, say, take my student to the hospital by ambulance, we get a directive from EMTs on site that it needs to be done. So we're trying to be very specific in making sure those notices go out correctly and that we're opting to select what is important to meet the health of the students while still understanding the needs of what the parent has made a selection for whatever purpose. It could be a personal decision that they make that they don't want the ambulance to take them to Children's. It could be a religious reason for vaccination. We have to understand exactly what it is, and that is where we were getting with this.
Yeah, and that's something that we have, I mean, that the school goes through every year.
Well, it actually, right now, if you do not opt out, the default is you've given consent, but we want to make it more detailed.
Right.
And one other, if I may, Pastor Harrison, the sexuality content, just kind of like looking over it again when you asked, is anything that we're not currently doing. We do have a process by which families can review instructional material. I don't know that for sexuality content, so that will be new. A process for the any components that had that material.
But that's in place already. And I guess that's what I was looking. Is this going to increase the workload by requiring us to do something that we're not currently doing? We have the emergency cards. You know, if you want to go to the hospital, not you can take my son, daughter, yes, no. You know, is this creating an additional work thing?
Oh.
Yeah.
I do not think so. I mean, and as I look at, of course, you know, when you get into the thick of it, right, and start making sure that the processes are in place.
Yeah.
But when I look like at the one about any notifying families of substantial changes, that's good practice, and that's what we do. You know, something changes in your student's mental, emotional state or what have you, there should be communication of that.
Okay, thank you. And my other question is, we have Red Oak, we have minority behavioral health in the building. Do we incur any responsibility from what a child would tell one of their counselors?
Say more.
Okay, you know, there are providers that we allow in the buildings, and so I go and I tell one of the providers, hey, you know, I'm not sure where I am sexually. Okay, so that's a conversation that they have with that provider. Do we incur any responsibility in that because we don't have communications with the actual counselor or session, but it may have taken place in our building? Do we have any responsibility in a situation like that?
So that session with that provider would be confidential, and so whatever they share is in confidence. However, we're all still mandated to make reports of anything that would be of danger to that individual or others, and so we would have an obligation to share information. But if that child is open for services with that provider, then that's protected.
Them. Okay. My last question with this, how are we training our staff in this process?
Great question. So as we discussed the Parents' Bill of Rights, we realized that this is just part one. There's a lot more work that needs to be done. So I don't have an answer for you right now other than that is on our minds and is in process and will be.
Thank you.
You're welcome.
Okay. Any other questions? Yes.
Sorry, not a question. I just wanted to circle back to Dr. Molnar's question really quick. So as Dr. Lash pointed out, we do have our 5517.01 policy, which requires annual notification of our bullying and aggressive forms of behavior policy. And then also this, really quickly here, underneath the student services, mental, emotional, physical health, that heading, the first heading on the second page, that's requiring notification, including counseling services or monitoring related to the student's mental health, emotional health, or physical health. So C, which is the harassment, intimidation, or bullying, is included in that definition of students' mental health, emotional health, and or physical health. So I just wanted to address that now so that we can close the loop on that. Thank you.
Yes, Dr. Molnar.
Thank you. Yes, so because that was very, very quick. So to close the loop, because this is, from my understanding of 551701, was the students have the right to file a complaint, and the students have the right to have that complaint be investigated. But there was nothing in 551701 to notify the parents of their own students filing. And so I thought the Parents' Bill of Rights was the opportunity to notify the parents that the student has been involved in something. And so you're saying that if a student files a complaint as it's related to item C, that parents will receive documentation on here, on
Yep,
that?
that's right. So it says here, so I'll slow down a little bit. Sorry, I was trying to speed us along here. But the board, school personnel, and/or contracted services will promptly notify a student parents of any substantial change in the student services, including counseling services or monitoring related to the student's mental, emotional, or physical health or well-being. So if you go to the first page, A through E is the definition of students' mental, emotional, or physical health or well-being. So yes, and incident of harassment or bullying with the student would be included under that paragraph.
So you're saying if a student files a complaint on bullying, that constitutes a substantial change in mental health, and therefore the parents would be notified?
Well, it constitutes, I believe it would constitute any harassment, intimidation, or bullying. So because the student's mental, emotional health, or physical well-being is included there.
Okay. So that would be a difference than what we're doing presently. to
I'm just saying
notify
that I
families.
think that the policy addresses what you were getting at, but I don't know if, am I missing?
Yes, I mean, I'll speak a little bit on this here. I know that and I don't know if this is still true, is there's some bullying or intimidation going on in the building. Students have a right to fill out the form. Once that form is filled out, it should go to a specific person. Once it goes to that specific person, with normally the school administrator there to see what's going on, look into it, and they could notify the parents themselves of what's going on and what's happening with this kid. I think that's what policy states, that we should be doing that as far as harassment, but I'll let them make sure it's clear, and we'll make sure that's what we actually do, because I think that's part of what we've been doing for.
I would like to advocate for, in the Parents' Bill of Rights and/or in 5517, that we would provide parents a form of written documentation, and I think an email would still count as written documentation, if their student files a complaint about bullying or harassment. I think that is something that we should explicitly state.
Well, we'll have them look at that and come back and let us know the next meeting. All right. Next, policy 5136.01, electronic equipment.
Haley's going to speak on electronic equipment. It is kind of a addition to our current personal device policy.
Yeah, so we have on our books a personal communication device, and this kind of expands upon that to disallow certain kinds of electronic equipment. So there's prohibited devices that were not included in the PCD policy, which includes cameras, cameras, radios, headphones, things that are not internet enabled. But more importantly, this policy has a section on accessing and monitoring school issued devices and accounts. So this is a requirement by Senate Bill 29, which was later, there were some changes to these provisions in House Bill 432. So there's general prohibitions on monitoring schools, and contracted third-party technology providers can't access location data or audio features, student interactions on school-issued devices. And then there are certain exceptions to that where you'll see A through F. So in instances where there is non-commercial educational purposes, warrants or subpoenas, if the device is missing or stolen, and if there is a threat to life or safety or compliance with state or federal laws. And then there's also the parental notification requirement, which states that schools must notify parents within 72 hours if access is to the student's device is prompted.
Any questions? Pastor Harris?
Just a brief question on the first paragraph. And I think we ran into this with the previous discussion. Policies that send us to another policy. And I'm looking at the last sentence in 513601. Students shall not use personal communication devices or possess any electronic equipment or devices on school property or at any school-sponsored activity without the permission of the principal, as is referenced in, I'm believing that's policy, PCD. So when I first read that, I'm thinking, wow, well, that means, sporting events and da-da-da-da, until I went to 5136. And so I would think that last line, if we can just put the beginning of 5136 in there, so students may use personal communication devices before or after school or during the lunch breaks, during the school activities, extracurricular activities. I think instead of sending someone to another policy, let's just spell it out. Even if it's redundant to this, if we can just put it in there. I think it's always better not to try to send someone to another policy to get a clarification. Am I making sense? So if we can just add that.
Okay, yeah, we'll make those adjustments and bring it back for discussion next meeting. We'll make those adds.
Perfect. Okay.
Mine was just a comment that it was kind of, we did it in the last one, referring to another policy. If we can just put the language in there.
Okay. We got
Okay.
that. Okay.
Next is new business, and on new business, we have a policy, a draft policy that has been brought by the Equity Committee. So I'll have the administrator, Dr. Chapman, if you'll come up and give us a brief overview of this draft policy.
Mr. Chair, for the purpose of this conversation, for the purpose of this item, there's a conflict of interest for me, so I will not be participating in this.
Noted. Thank you, Pastor Harris.
Thank
Dr.
you.
Chapman?
Thank you, Chair Alexander. So this draft is being brought for discussion as new business, and it is the result of 10 hours of policy crafting and review in the Equity Committee. And so what we did in the Equity Committee over the past 3 meetings was to review language from what was the existing racial equity policy 2260.07 and what we wanted to continue in new policy, and while also sticking to the spirit of that particular policy in terms of the values and the commitments and the work that we want to see continue in the district. So this unnumbered policy is being suggested to be called the Comprehensive Operations and Institutional Oversight Policy. And it goes through purpose. It lays out as it has in the past. Who's controlling this? Oh, okay.
Have to use the.
So this policy, and I'm not going to read it all because this is a new business discussion, takes us through the board's commitment and the purpose of the policy, and then it lays out for you each area of consideration by the Equity Committee for implementation and operational actions, what should be considered in teaching and learning as an aspect of the work in our district, the commitments of the leadership, our family and community engagement, what is important for student discipline to consider, and then our practices around recruitment, screening, hiring, and retention of highly qualified staff, and then ending with suppliers and procurement, finances and resource allocations, the composition of the board committee being suggested to be named Comprehensive Operations and Institutional Oversight Committee. And then again, naming an executive director level position and further commitments of the superintendent and the board around this policy. And then I would defer to the other drafters of this draft policy to chime in. Mr. Chair.
Okay. All right. Anyone wants to start the discussion? I haven't really got a chance to read it, so I'm going to let you guys, since you brought it here, talk about it, and we'll get a chance to hopefully read it and digest it.
Thank you. I think, as Dr. Chapman started with, this was a labor of 10 hours of co-creating with board members, administrators, community members came and gave input, and I am really proud of how far this document has come. It's currently unnumbered. We had previously a racial equity policy and an equity policy. It was 0.04 and 0.07, and so this is envisioned to be a new policy, so it'd be 0.06. Is what we are proposing to the legal committee, but what I believe the intention is from this is to give this to the legal committee to review, make sure that everything we put in there is legal. And then have a discussion and go through the appropriate process from here. So, thank you. I don't know if...
Okay. Anyone else want to comment on it? Okay. Since this is new, I think it's good to be able to look at it and review and be able to digest it, and we can come back and talk further about this, so we would give everybody an opportunity to read it. So I think that would be appropriate for us to do. Is there any other concerns or any other thoughts in that? Okay, so we will take this and be able to look at it and read it, and hopefully maybe have some further, well, I shouldn't say hopefully, but have some further discussions on this policy to see where we can move with it. Okay? All right. Next, madam.
All right, so that's all we had for today. And so on our next agenda, we will bring back those policies that we talked about as relates to being under discussion, as well as our new draft policy after legal has an eye and gives us feedback.
Perfect, thank you. Also, when you guys make the changes, can you put them in bold so we can see them, the changes a little better?
Yes.
And that way we'll be able to see the changes as well. Okay, anyone else have any other questions or comments or concerns before we end? Questions, comment, concerns? Going once, going twice? All right, we're adjourned. Thank you, everyone, for tuning in and everyone who was here to participate.